I'm so excited for this panel, for all of you for staying and for the great group we've got together. Ideally, we're going to be mapping some of the solution space and mopping up some of the issues from the last 2 days. Since we're a few more voices up here, and so that we change it up, we're going to do a little lightning round of a minute each from each person, and I am going to be strict with the time to the extent that you'll hear my 1 minute clock. So what they're going to do is, in 1 minute, tell us about a project that's coming or that's passed, and I'll tee them up. So we're going to start with Andrew Tutt, who's an associate at Arnold and Porter, and a paper of his that's super interesting, it's been mentioned a couple of times, is around an FDA for algorithms, which he published in 2017 in the Administrative Law Review. And it sort of sets out a range of possibilities for what a federal regulator might do in the algorithmic space. So, Andrew, do you want us to tell us in 1 minute a project you're working on or thinking about?
Sure. Oh, yeah, these are loud.
Yeah.
So I mean, I wrote an FDA for algorithms, 2 years ago, and it ultimately came out about a year ago. And, one thing that's interesting is I was talking to Julia, and she said, it's become cliche, throw around FDA for algorithms or whatever. But it wasn't actually cliche at the time that I was originally writing it. It is a great slogan, although one thing to emphasize is that I was literally proposing a very sort of close analog to the FDA in the paper, and you can see I advocate for it to have pre-market removal power, pre-market approval power, et cetera. And it was a very aggressive stance. In some ways, I still stand by sort of everything in it, but it was very abstract. And the project that has been ongoing
In 20 seconds.
Yeah, in my next 20 seconds. Okay, but how do we get from the big 50,000-foot view and this regulator that I think is inevitable to the first step in the implementation of that sort of vision? Where would it fit into government currently? What would be the very concrete steps that we would take to actually build our first sort of algorithmic regulator in the United States? And that's
Beautiful. Now we have Natalie Ram, who's a professor at University of Baltimore, has this terrific paper, Innovating Criminal Justice, which I think is really following through what's been a bit of a case study theme of the last 2 days. Is a really beautiful piece that she's going to speak to. But in her minute, she's going to talk about one-shot learning in criminal justice. Go.
Yeah, so innovating criminal justice, and in a few words, is in addition to trade secrecy and also patents, which Nicholson told us why that doesn't work. We also have prizes, grants, regulatory exclusivities, and tax incentives. Okay, so we can talk about those later. Now, just 40 seconds on one-shot learning. This is the idea of teaching computers to learn how to learn. We give them lots and lots of training data about one kind of item to analyze, and then we introduce them to different kinds of items to see if they can learn how to make determinations about new categories. And I think that can exacerbate some of the existing problems with algorithms in the criminal justice space. It's yet another layer of abstraction, and more stuff that could be hidden away and protected by trade secrecy. And insofar as learning how to learn means learning to use heuristics. Heuristics are shortcuts and often imperfect, and so that could make us even worse.
Beautiful. By the way, we're going to get plenty of time from these people. They're all going to get 5 to 8 minutes. This is just warm up. So next we have Colleen Cheen, who's a professor at Santa Clara, has this paper forthcoming in Iowa Law Review, Experimentation in the Administration of Law.
Hi, it's great to be here. So that paper is going to look at experimentation in general, but it looks a little bit at AI and how it can be used to improve regulation. So that's one project, and then I'm excited to talk today about trust and trade secrets, which is going to be another project.
Right. Next we have Andrew Selbst, who's a postdoc at Data and Society, has a great set of papers, and I wanted to just mention one past because we worked on it together, and it has a little line about trade secrecy. This is a piece on meaningful information and the right to explanation. And we were particularly responding to some European scholars who were not trade secrecy scholars, I think giving great deference to potential restrictions on a right of data subject to be explained, algorithmic decisions. And we just had this line: there's no justification for treating trade secrecy restrictions as axiomatic under an entirely new law with a new emphasis, which was to the GDPR. But Andrew, tell us, 1 minute, new project.
All right. So earlier, Jeannie mentioned the technical folks, the CS folks, trying to address fairness in algorithms for various, with technology. There's this whole field or a new conference called Fairness, Accountability, and Transparency, FATSTAR, because it's in a bunch of different computer systems. And myself, Dana Boyd, Suresh Venkatasubramanian, Sorel Friedler, and Janet Vertesi have this paper coming out at that conference, sort of looking at how the training they get as computer scientists shapes the way they think about problems and has them run into certain traps that stop them from being able to achieve the fairness goals they seek. And one of those traps, for example, is trying to define fairness in a formalistic mathematical way, but there are a whole bunch of others. Then we use theories from science and technology studies to sort of situate these observations in theory and then make recommendations for how computer scientists can work with social scientists, lawyers, and philosophers, and proceed in actually trying to get towards fairness solutions. What I'm going to talk a little bit later, I'm going to talk about one of these STS theories.
Perfect. Next, we have Sonia Katchel, who's a professor at Berkeley, has 2 great papers that are coming. One on rethinking private accountability in the age of the algorithm at UCLA Law Review, and one on the paradox of source code secrecy. So you can pick what you like, Sonia.
Okay, thanks. Thanks so much. It's great to be here. So the private, I guess both of these papers stem from my. Perhaps this may not be the best way of describing myself right now, but I'm sort of a tech optimist. Like, I try really hard to look for the best in the field of technology and in business. And so the private accountability paper is really kind of recognizing the fact that we have a real absence of regulatory possibilities at the federal level, to put things mildly. And so thinking more broadly about different ways to incentivize private accountability. So in the paper, I talk about codes of conduct. I draw on Andrew's work on impact statements. But I also talk about the emergence of whistleblower protections, which is a little appreciated provision in the Defend Trade Secrets Act, and how whistleblower protections might lead to greater transparency. And then the source code secrecy piece is really...
Oh, we're going to hear about that after. It was so beautiful. Yes. Vincent Sutherland is a colleague here at NYU. He's the executive director of the Center on Race, Inequality and Law. Has this very recent report from their center from a series that they've been doing with the ACLU on what does fairness look like. Conversations on race, risk assessment tools, and pretrial justice.
Sure. So I'll be very quickly. Thank you for having me here. The report is kind of a follow-up to a convening we had in November of 2017, where we brought together data scientists, advocates, community organizers, a range of people who are involved in the design, oversight, and implementation of risk assessment instruments, particularly in the pretrial justice space. And the question was, how do you define or determine fairness when you think about race in that context? We didn't get an answer to that question at the convening, but I think what we did do was come up with at least some set of agreed upon principles that everyone in the room, folks who were making the tools to the folks who were kind of, tooth and nail fighting against the tools in their use and implementation. And the kind of the agreed upon notions were that the tools should really focus on reducing racial disparities in the criminal legal system, that they should act in a decarcerative manner, that it should be better understood by stakeholders and the people who are implementing them, and that they should be subject to community oversight and community input in terms of like the people who are being targeted and being judged by these tools. So those are kind of some of the major takeaways and kind of some other areas for research going forward.
Perfect. All right, great. This was just to warm everyone up as to timelines, so that we can make sure we get through everybody. But I'm going to turn now, we're going to go through the group. I know you've all been thinking through the last 2 days, but also from your own work on some directions towards the solution space and other thoughts you want to throw in. So we'll just go down the line. Andrew.
Sure. So the sort of big questions that I've been grappling with for years that are still evolving is sort of what is the sort of right regulatory level at which to regulate? Should it be state, federal, local? And then sort of what should be the right sort of regulatory way to frame algorithmic regulation? Should it be through using the algorithm as the center of regulation and then having substantive values sort of implemented by the algorithmic regulator? Or should it be that substantive value regulators treat algorithms as sort of a special case and that it's really just old wine in new bottles? I'm privileged to be on a panel with people who think about this all the time. And so I personally believe that at this moment, we're in a different regulatory environment than we will be in 10 years. So I believe in 10 years, it will be axiomatic that the proper unit of regulation will be the algorithms, and that substantive values will be sort of policed by the algorithmic regulator, or that the algorithmic regulator will be the sort of center of gravity. And I believe that because of sort of the trajectory of algorithmic development in terms of the complexity of the algorithms that we're deploying, the pervasiveness with which they sort of engage with us in everyday life. And I think that's only going to become much more baked in and much more pronounced, such that I think I was making the analogy earlier, which is more complicated to understand, gender discrimination in the workplace or the algorithms that are making decisions that lead to discriminatory outcomes. And I think in the future, increasingly, it will be obvious that it's actually the algorithms, and that that sort of the EEOC, which is currently sort of the site of that regulatory regime, will be sort of incidental. They'll be helping to say, okay, well, we want them to do this outcome, and they'll be talking to the algorithmic regulator, which will be the principal driver of making sure that algorithms are tested and approved and put together in a way that actually implements those substantive outcomes. But I don't think we're there yet, so there's a little bit of an element of the time lag. And that's what I have on that.
Okay, so yesterday I talked a little bit about the types of technologies across the criminal justice space and how that can jeopardize or be in tension with our constitutional commitments to a variety of constitutional principles. And other folks have spoken to that as well. And so that raises the obvious question, what are we supposed to do about that? If trade secrecy is causing all these problems, what response might we have? So I think Kathy and Eli gave us one solution, which is, well, trade secrecy may not even be necessary to incentivize innovation in this space because of the first mover advantage. So ditch trade secrecy, not necessary. First mover advantage is all we need. But even if, some sort of incentive to innovate is required, trade secrecy isn't the only, innovation lever that exists. Nicholson talked a little bit about patents and why patents don't apply in this space, right? But, a lot of scholars are focused so much on IP that when you run out of patents and trade secrets, what else is there, right? But it turns out there's this whole other panoply of tools, including, as I said, prizes, grants, regulatory exclusivities, and tax incentives. And what's awesome about all of these is that they don't require secrecy. They don't compel non-disclosure by their own terms, but they can be effectuated with a disclosure requirement, right? And many of these, interestingly, are already in use in the algorithmic development space. So when I was writing my paper, I went and looked at what kinds of prizes are currently being administered through the federal government. There's a whole prizes website. And I discovered that at that time, I don't know if the prize has been claimed, but there was a prize available for kind of the best solution to develop algorithms that advance place-based crime forecasting, right? So we talked about why place-based crime forecasting might be problematic, why we might want access to that algorithm and its training data. And here's a federal prize to create those kinds of algorithms and make them better, which doesn't necessarily come coupled with a disclosure requirement, but could be coupled with a disclosure requirement. In order to win the prize, you've got to produce your algorithm and your training data and make those available for outside validation, right? Grants, which are also state administered, but instead of kind of rewarding successful innovation after it happens, actually incentivizes or defrays the costs of doing innovation by paying upfront to the folks the government entity providing the grant money, guess are going to be the most successful innovators in the space, right? So that's a different time for investment of funds, but still an incentive to innovate, right? And Mark Perlin, right, our much mentioned developer of Trulio, was awarded 2 small business grants, which if you look at what they were awarded for, they look like they were probably related to the development of Trulio. So he got some grant funding on the front end and then uses trade secrecy on the back end to, double dip in the innovation space. Not all that uncommon in this kind of double dipping, but a fact nonetheless. Now again, grants don't necessarily come with a disclosure requirement, but could come with a disclosure requirement. And in fact, disclosure requirements are growing. So I think federally funded genetics research or big data research now has to, contribute certain kinds of health data to federally administered databases. And so that's something that could be done in this kind of algorithm development space. Regulatory exclusivities, that refers to the idea, and let me know when I'm going on too long, that if there's a government entity that's kind of in charge of approving a technology, they can approve it and say you get to own the market, you can have a monopoly on the market or this part of the market for a certain period of time, right? It's where patents aren't available. We use regulatory exclusivities to create something like that. And I think that we can look at procurement contracts that say, hey, Compass or hey, StarMix will only contract with you for 5 years as a kind of a regulatory exclusivity, right? And again, those could be coupled with disclosure requirements, not necessarily so. And then there are a variety of tax incentives under federal tax law and also could be accomplished on the state level to incentivize investment in innovative work and also defraying taxes on income from, say, patented goods or other types of innovative work, right? Now, I think that these other types of innovation levers are well suited particularly to the criminal justice space, because in that space and in the public sphere more generally, you've got the government is the primary purchaser and the primary funder, right? So often we see a disjunction, people don't like grants because it's the government picking winners, right? Especially ex ante, right? Or they don't like prizes, but they prefer patents because that's the market decides, right? But here, the government is the purchaser. And so we have this kind of distinction of who's picking winners kind of falls away. And so prizes and regulatory exclusivities maybe look pretty similar. And so I think that these kinds of tools suggest that even if we need incentives for innovation in this space, we can get those kinds of incentives without just deferring to trade secrecy. We have alternatives and we should use them.
Great.
I'm going to actually present a few slides.
Please.
Oh, sorry. So I'm just going to present some early work and some thoughts on solutions in this space. And I am a primarily patent law specialist, but I also do some criminal justice. And what's common in those two realms is that I'm really focused on data. So I'm coming a little bit at it from a practical perspective of doing data science in my empirical work, and now doing a lot more of it working actually with a team of data scientists. So I'm at Santa Clara. I also am affiliated with the Stanford Computational Policy Lab. I also worked in the White House as an innovation senior advisor. And the reason I mentioned those two last contexts is because in a lot of these environments, I'm the only law person. And so I'm dealing with tons of scientists and data scientists who are just trying to do things and solve problems that they're seeing. And so they don't really think about the law when they're doing that. And so I'm trying to bring in their experience a little bit in this presentation as somebody who just happens to be able to sit at the juncture of both areas. So in summary, I'm just going to make 4 points, and I think one thing also I would say about myself is that I've been known to like say obvious things, but in data. So I'm going to say some things that are probably maybe obvious, but I hope I get some pushback as well. But I want to first establish that there is a distrust of algorithmic systems. It's pervasive, and I'm going to show some data on that that's just brand new. It's also historically grounded, and we just need to acknowledge and I think call and name that. I think trade secrets and trust, I think that one of the premises of this conversation today is that they are all often at odds. But I want to point out in some ways that I think that they're not necessarily at odds as a way to then look at solutions. So the 2 solutions or interventions I want to talk about are leveraging the tools of technical development and technical accountability to support both trade secrecy and trust, and think about accountability both technically as well as legally. And think about also how we map the normative values that we express in prose and through our own statements and legal documents into computer code, and how we can make sure that these 2 things are actually not incompatible with each other. So let me start with skepticism of algorithmic systems is pervasive, and I just want to present the results of the Pew Trust study that just came out yesterday, and the headline is, the majority of Americans find it unacceptable to use algorithms to make decisions with real-world consequences. It's an important study. I think anybody who's working in this area needs to be able to be fluent in what the public opinion and sentiment is here. So even though we have increasing uptake of algorithmic decision-making in all kinds of contexts, a lot of Americans are still uncomfortable with that, ranging from thinking about parole decisions, 56% of people think that's unacceptable, up to 68, nearly 70% of people think using personal finance scores for consumer data is unacceptable. And there's nuances here, and there's differences by race, and it's just worth reading these findings. But this skepticism and distrust is also historically grounded. So DJ Patil, who I worked with, came and gave a talk at Santa Clara, and he talked about the track record that's long of people using technology and data historically. Whether you're talking about Henry Latta Locks or the Tuskegee experiment, probably more poignantly, one anecdote that I had not been familiar with is the use of directories, phone books, to find Jews as part of the Holocaust, and to find names. And there's actually I don't know how well documented it is, but there is, at least in the data science world, there's a documented example of somebody who was a coder who basically hacked that intervention by basically having the data stop at a certain point. If you look at that community, there was a lot less infiltration or, I guess, activity there. And there was, a data scientist or a hacker or a person, whoever you want to call it, who decided, and this person, I don't know his name, decided, that this was not a good policy, and that he basically took an intervention. So, the second kind of idea here is that we see trade secrets and trust as being at odds. And I think we've talked about this, obviously, and I missed all of yesterday, so I apologize if this is sort of redundant, but the idea is that if we can't see it, we can't trust it. If we can't, kind of know all the details, we can't have accountability there, and we're just not going to trust that system. So we sort of elide that sense of, since we can't interrogate it, we can't guarantee that it's fair or that it's accurate or that it's trustworthy. But I want to say that there are public and private interests in disclosure are different. I think it's important to actually look at the workflow that is involved when you do data science. Okay, so, and this is something that I'm very intimately and familiar with, and doing a lot of data cleaning all the time, so it's extremely, it's kind of painful, but I'm involved in doing a lot of this. So you're taking inputs, right? You're taking data that's new, and you're cleaning it. That's 90% of your work. Then you're putting labels on it in a supervised environment, or you're feeding it into a system, but you still want clean data. And then you're trying to figure out, well, what actually is important? What do we want to look at? Then you're going to be applying algorithms and try to put those into different groupings, and then develop some kind of prediction based on that. And so when you're doing this work, I was presenting yesterday on a panel with Amanda Agan and Sonia Stark, who are these amazing economists, and we were both all talking about each other's work. And it was interesting because I think, afterwards we were like, well, how did you do that? How did you do that? We want to know about process. I want to know, they asked me, how did you get your data? Where did you get that? Who gave it to you? I want to know, how did you get an IRB to let you do that, what you did? And I want to know about process. So as a competitor, in some ways, you're interested in process because you don't really have the same data set. You have your own data scientist, your own model. You have your own comparative advantages. You're not trying to just take exactly what they're doing and map it on. You're trying to ask them about their process and what they did. did. And so competitors are really interested in process. They want to know, where did you hire? Where did you find these people? How did you make this price so low? Where did you get your data? How did you clean it? What pipeline? What's your data cleaning pipeline? That is a huge issue in data science. But defendants and members of the public, I believe, are more interested in performance. They want to know, well, what's the accuracy of this? They do want to know a little bit on the edges around, like, what are the data sources, what are the features? But those are at the higher level. They want to know, how does this perform compared to historical models? What's the sense of what kind of assumptions are you making? They're looking at these things that you can see from the outside, but they're not as interested in the internal mechanics that I would say competitors are interested in. And so I think this does provide support for the idea that walled gardens or other types of disclosures that are controlled can still respect both innovation and trade secrets, as well as providing some sort of accountability. So my interventions then are to try to leverage the tools of technical development to support both innovation and accountability. And so I was working with a data scientist on some of my recent projects, and I was asking him, before I could present something, I had to redo it myself. So I had to ask him sort of like, what are the things in industry that you use to try to evaluate if you're given a data set, you're supposed to develop a model, how do people evaluate that? So here are some just very basic, any data scientist would probably know these tools of accountability, right, and technical development. So one is to actually check how people check your code, right? It's usually like a Jupyter notebook. You look at the statements, you look at the documentation, you check that, and you might do some validation. There's also, sort of auditing up what the assumptions are. And here's where the data scientist often is not a domain expert. They have to work with them to figure out, how do I model this? What, do I put this as dependent or as variable, et cetera? And so, what are the features that we pick out? How do you specify them? How do you define them? That's extremely important. And then actually being very explicit about what your hypotheses are. Like, why are you including that feature? What makes you think that's important? And sometimes it's opportunistic, but at least saying we don't know if this works, we're just doing it, is again showing it's a good technical practice to be thorough in your documentation. Agile development is the kind sort of referred to earlier, having iterations in different levels of code. I'm not going to go through the rest because I know I'm running out of time. So I'll just leave that for the Q&A later. But I just want to give two examples of how this can be useful in two specific spaces that I've been sort of paying attention to and plan to engage a little further on. So one is on the leadership conference statement, which it sounds like Vincent was involved in helping draft. So that's great at NYU. And that was a huge statement that was done by the civil rights community in July of this year that said basically we don't think risk assessment tools are trustworthy, but if they're going to be used, we should use certain principles. And the other is the First Step Act, which is advancing now. The president just decided to endorse it. So I'll just talk about that really briefly, those two ideas. Or am I not? Okay, I'll just go through really quick. Okay, so leadership conference, basically, it came up with the principle saying that pre-trial risk assessments should be developed with community input, revalidated regularly, subjected to regular meaningful oversight. So we can think about this as translating into certain practices where we would have independent peer review of the coding that was done, that we have iterative processes where things can be improved, right? It's not just a black box that stays static, but it can be developed over time. I think one thing that I think is personally, myself, is very meaningful is thinking about the community defining the risk rather than some independent source. So we keep on talking about recidivism, but the concept of recidivism in itself assumes that reoffending is violating the law. And you can violate the law by not showing up to your probation meeting, or you can violate the law by killing somebody. Those are totally different things. And I think this is a fundamental flaw. When we talk about recidivism, we talk about reoffending. We are essentially coding reoffending as a binary variable. You've either reoffended or you haven't, rather than as a continuous variable, which is what it is. It's many different possible outcomes. And so I think this is something we need to talk in both languages to get there. The First Step Act, it shows a picture because the person on the right is a former student of mine, and she's been very active. Her husband was formerly incarcerated, and she's actually why I've done a lot of the criminal justice work that I have. But the Democratic leadership came out and basically talked about some of the things Vincent mentioned in his introduction, maybe he'll go a bit deeper, saying that we are really worried about the exacerbation of disparate impact. But we can think about that. Instead of looking at accuracy, we can specify that our dependent variable will be race-based in consideration of past versus present. So we can, the basic point is that the technology is flexible. It can encode our values and it can reflect them. And so I think having this conversation is useful.
great. You guys can choose whether you want to look at them or what you want to do. Andrew.
Well, I don't have any slides, so I'm gonna. Okay. Anyway, I was originally planning to talk about algorithmic impact statements, which have come up a couple times and we're on a solutions panel. But like I said, I want to instead actually introduce a theory from STS called the social construction of technology. And the reason for this shift is because I noticed that there was this theme between yesterday and today of emphasizing sort of the social aspects of this ecosystem. So Gina talked about looking at the interests of developers versus deciders versus those decided about. David, when he talked about the Tay example, noted that problems with algorithms are often social and not technical. Rebecca talked about how the interests of the technologists are warping the way we even think about law. And Scott, as the theory is called, is sort of about all these things. So forgive me, I am going on a little bit of a limb here because I'm a lawyer, not a sociologist or STS scholar, but because of my position at Data and Society, I get to play one on TV. I came across this theory for this paper, which I had mentioned before, is like making an intervention directly into this primarily technical space of FatStar, where you have a lot of machine learning people thinking about how to encode fairness into their algorithms, and we're suggesting ways in which that process can be improved, partially by thinking about it as a process. Okay, so Scott. Scott was developed by Trevor Pinch and Wiebe Biker in the 80s. In 1984 was the main article. They observed that while we look back from the future at a technology, we tend to see a single object, as if the technology just sort of emerged fully formed. But the path of technological development is not linear. So they used the example of the development of the bicycle. Originally, there were many different versions of the bicycle, and I'm sure you all remember photos of like the huge wheeled bicycle, right, and the tiny wheel, things like that. Well, so some versions of the bicycle were better for speed, some were better for safety. Not all versions had air-filled tires, and they were debating about whether air was necessary in tires, and it solved a vibration problem. What they found was that each version of this technology solved a different problem for a different social group that considered that the purpose of the technology. Right? So some groups preferred safety. Actually, they all pretty much liked that. Some preferred speed because they really saw bicycles as only for sport. You might imagine these were kind of rich men. Eventually, the technology stabilized into what we know now as a bike. I mean, there are variations, but we have a pretty good idea of what a bike looks like. Right? So the key concepts to this theory are interpretive flexibility, relevant social groups, and stabilization or closure. So interpretive flexibility is the period in which the tech is relatively unstable and needing to be defined. Relevant social groups can be you and me, can be governments, can be companies, really anyone with a hand in defining the technology by voicing what problem they think the technology is trying to solve. And the groups are the ones that are trying to have problems solved. So stabilization and closure are the point at which interpretive flexibility sort of ends, and the technologies are, in a sense, done. But technologies are not necessarily closed forever. They may never get closed, even if they sometimes seem to be closed. So this is the concept, right? At some point, we have a pretty stable idea of what a bike looks like. We can look at one, and actually probably a computer can tell you if it's a bike or not. But the important part of the theory is that it states essentially that technology gets defined by these relevant social groups jockeying for position to better solve their particular problems. And so the technology that stabilizes doesn't stabilize because it has some best version of the technology. And that claim makes total sense, right? If you have a new technology, what does it even mean to have some best version of it in an absolute sense? The only way we can think of the best version is think of the different problems it solves and who that helps. So there's no natural winners of technologies. And you could think about all the tech that's stabilized, but we're not entirely sure why. So why does Blu-ray exist but not HD DVD anymore? I have no idea, right? 8 tracks. Does anyone remember Zune? Like, I don't think people would say that Zune was necessarily worse than other MP3 players, but for some reason or another it ended. But anytime you have different social groups competing, you end up with concerns over power. And that's the really, I think, biggest takeaway here. So Ruth Schwartz-Cowan wrote an article, How the Refrigerator Got Its Hum, and this tells the story pretty nicely. So there used to be something called a gas refrigerator, as opposed to an electric refrigerator. It was like 100 years ago, and it was much more reliable, didn't break, and it didn't hum. How annoying is that, like, refrigerator hum, right? We could have all had refrigerators that didn't hum. Except, turns out, GE and a couple other big companies, though they were late to the refrigerator game, had a lot more money to push advertisements, to get their product out there. Now, of course, nobody here is going to be shocked by this idea that big companies have a lot of power to go. A lot of power to like push their product and dominate a market. But what's interesting is that it has defined the technology itself, right? So right now, when we think of a refrigerator, a constitutive part of a refrigerator is that hum. So back to today, right? Algorithms used for decision-making are in a period of interpretive flexibility. If you have any doubt about this, we can see it by the fact that we keep switching terms. Are they AI? Are they ML? Are they algorithms, big data, data mining? No one knows because it keeps shifting, right? So the problems of relevant social groups for companies, they're like efficiency and maybe reduced labor costs. For judges in the criminal justice system, they might be also about efficiency. They might be about apparent neutrality. For certain advocates, risk assessments allow us to get rid of cash bail by saying we're only going to keep the dangerous people in instead of the rich people. Everyone has different claims to what this technology is actually trying to do. So when you think about trade secrets, Scott suggests that when companies assert trade secrets and fight transparency, they're really doing two things. One is using whatever tool is at their disposal to define algorithmic decision-making as a technology that is secret and not subject to examination. So, other technical researchers have put out proposals such as data sheets for data sets, right? This proposal is near to my heart because it's sort of based on electrical engineering, and that's where I come from originally. It's modeled on if you buy a chip, like an amplifier on the open market, it comes with a data sheet that tells you how it was tested, that tells you what its limitations are. Like if you put it in a really hot product, like temperature hot, the performance will decline, and it'll tell you how much. The data sheet is part of the product. We all understand that. Anybody who buys chips or uses chips and a board understands that the data sheet is part of the product. So that's why the definition of the technology ends up being important. The second thing is using their power, right? The second thing that companies do when they when they assert trade secrets is use their power to block access to the technology in order to prevent all other relevant social groups, including users, the government, and those being affected, from being able to define what the technology turns out to be. So for judges and, say, probabilistic genotyping, the judges are interested in good evidence for their cases, but if they push back, they can also be seen as asserting their own view, that actually, okay, they need evidence, but they're defenders of the legal process, and so for this technology to be useful, they also need something that satisfies due process. But what the companies are doing by asserting trade secrets, and prosecutors are helping them, is saying, no, this technology is not useful for due process, or you don't get to define it, judge, we do. And it's this power struggle about definitions of the technology that Scott is really putting out there. Do I have any time left?
13 seconds.
13 seconds. Okay. Yeah, okay, I'll leave it there.
How
Okay.
perfectly timed.
Awesome. Well, it's great to be here. This has been a really fascinating discussion over the last 2 days on a whole variety of topics. So what I thought I might do in terms of kind of addressing solutions is to talk about some of the themes that we've been talking about over the last couple of days and maybe chart out a couple of different possibilities. And I guess one sort of basic observation that these conversations reveal is the way in which the world that we're living in actually exposes, and this conversation actually exposes the limitations of law, but then also kind of reveals some of its possibilities. And so I want to talk a little bit about some of those possibilities in terms of articulating kind of a fundamental rights framework. But I also guess, I also want to just explore some of the ways in which law can offer us some narrower and more granular possibilities to address the problem of algorithmic transparency. So let's start with some of the broader possibilities. So to me, the biggest way to address some of the conflicts that we see is by framing these issues not just in terms of the impact of algorithmic decision-making on the population, but rather in terms of articulating them through the lens of fundamental rights, right? So who is getting surveyed, who is facing these decisions, and who has interest in algorithmic disclosure. And the reason that I think this reframing can be really effective is because, as many scholars have noted in the US, many of the rights that individuals enjoy, particularly privacy, are kind of contextualized through the lens of a market-based framework. And this differs, I think, from some of the rights that are enjoyed by individuals in places like Europe, where the trajectory and the expression of individual rights are articulated through a different framework, which is less market-based and more through the lens of fundamental rights. So what would it mean if we looked at some of those insights in this context? And I guess here I'm thinking about how many of the presentations that we've seen over the last couple of days have actually spanned a bunch of different personas. And maybe by thinking about the fundamental rights that we might attach with each persona, we might actually come up with a bunch of possibilities. So the first one that I'm thinking about is the rights of the consumer. So too often, I think we frame these issues as a set of issues that affect ordinary individuals, but actually the reality is many of the decisions that we're looking at through automated decision-making actually affect consumers. And so there may be room in consumer law to address some of these different issues by thinking about the rights of the consumer. And so this allows us, I think, to turn to things like the FTC, the Fair Credit Reporting Act, Fair Housing Law, HIPAA, and explore how automated decision-making can be actually made more transparent. And so along these lines, right, think about something like the Consumer Bill of Rights, right, that was introduced some years ago in Congress, but actually has a lot of salience in this context as well. And the second is kind of exploring the constellation of rights that attach to the citizen. And this allows us to think about things like FOIA, due process protections, like those that Jason talked about with respect to the teacher case in Houston, smart city, open data, open source software in localized jurisdictions, using procurement language. So all of these different things, I think, are things that attach to the sort of constellation of the citizen. And the third might be a different way of thinking about the rights and entitlements and protections that apply to those that are sort of addressed through our criminal system, right? Which allows us to look at criminal law or criminal procedure and due process protections as an area of possibilities. So here we could look at the Sixth Amendment or Fourth Amendment protections. And even sort of broader, thinking more about impact statements along the lines that Andrew's written about. And this brings me to kind of the fourth persona that I'm also thinking about here. And this applies to the constellation of rights that might attach to the innovator, right? And so here we might think about how open source code or a reliance on the exceptions within trade secrecy might actually incentivize greater transparency. And so the case law that I've been looking at surrounding source code disclosure and trade secret cases, particularly in California, I think actually does kind of call on and utilize a really wide degree of protective orders and procedural protections to actually allow for source code disclosure and investigation. But this happens in infringement cases. And so I actually think that there's a lot of room in that space to draw deeper parallels between the infringement cases that allow for a wider degree of source code disclosure. Or we might think about the ideas that Natalie talked about in her great work in terms of thinking about how to incentivize innovation. And then finally, might also think about the rights of the competitor, right, in the space that Scott Hempel talked about yesterday. And so all of this makes me think about all of the different ways in which trade secrecy in many ways has been kind of weaponized in a way that it was kind of never meant to do. It was meant to be a body of intellectual property law that was supposed to protect against the misappropriation of confidential business information, not to protect against disclosure to consumers and investigators. And so that's why I think there's actually much more room in trade secrecy and the surrounding areas than people normally think of to incentivize disclosure. And so the last thing that I'll say, how much time do I have?
2 minutes.
Okay. And so the last thing that I'll say is brings me to the last kind of persona, and that is the rights of the investigator or the rights of the whistleblower. And so here I think we actually have to see that these issues of information asymmetry that we've been talking about are issues that have been dealt with in lots of other areas of law, particularly Sarbanes-Oxley or different kinds of compliance requirements. And so the piece that I mentioned earlier talks about how there's actually a special provision within the Defend Trade Secrets Act that requires protections for whistleblowing. And so there is kind of room within federal law, and there increasingly might be more room in state law in terms of figuring out ways to protect investigations. But I think the broader issue that I see is that this is kind of a crisis of transparency, as many of us have talked about. But I actually also see this as a bit of a crisis about fiduciary duty in terms of ways in which the law has kind of needs to think more broadly, but also more specifically about ways to protect the citizen, the consumer, the criminal, the investigator, the innovator. And so to the extent that we're relying on law to solve these problems, I think it's important to think about our lens of kind of fiduciary duty within the law. And I think that when we look at things in that way, we might see that there's actually more room in private and public law, I think, than people realize. Thank you.
Cool. So I'm going to take a kind of a giant step back in some ways in kind of my frame of my remarks. I approach kind of the algorithmic decision-making space with, I think, a healthy bit of skepticism. As a former public defender, someone who's represented people on death row, people who have been accused of crimes, large and small. What I've seen, particularly in the use of technology in the criminal justice system, is that that technology is, I think, often designed and implemented with hopeful motivations, but at the end of the day, more often than not, the technology just replicates the oppression and bias and harms in that system. I think I saw this kind of firsthand in my prior role as a lawyer at the Legal Defense Fund, when there was a rash of police killings in 2014, particularly the killing of Mike Brown in Ferguson and Eric Garner, who was choked to death on Staten Island by the NYPD. And there was a large call at the time in the civil rights community and a number of communities for use of body-worn cameras to try and hold police accountable in that space. And many organizations and civil rights organizations, racial justice groups were skeptical of that, but also a lot of groups signed on to that initiative, that viewpoint. And what we saw is that the body-worn cameras didn't necessarily reduce any police violence, but did present an opportunity for increased surveillance of communities of color. And now you have even kind of the concerns around Axon using the footage from body-worn cameras and combining that with facial recognition software to kind of broaden the net of suspects. That said, I do think there is potential to use technology for good, particularly in the criminal justice system, and potential with respect to kind of algorithmic decision-making. And I think one of the things that you saw, at least more recently, was a report or a study that was done by Jennifer Eberhardt and a number of other colleagues that looked at the footage from body-worn cameras in Oakland. And what they saw in kind of analyzing that footage was that when you control for officer race, when you control for kind of all these other factors, black motorists were treated with greater incivility by police officers than white motorists were. And so it kind of revealed kind of a deep reality about the way in which race operates in the criminal legal system and operates with respect to the way people exercise their discretion in that system. And so I think there's a powerful use of those tools in that particular way. I think to the extent that we're focusing on ways of kind of developing better and more helpful technology in these spaces, is helpful, I think, to have an overarching normative scheme and a set of values that we return to time and time again. For me, the set of values that I think makes the most sense when I think about the way in which the law and race and inequality interact comes from a field of thought that was actually one of the kind of the parents of this field of thought was a law professor who taught here, Derek Bell. And what that space is critical race theory. And I look at the world through that lens, and at least some of these problems through that lens. I think it'll become pretty obvious in a couple of minutes why. But I think that theoretical lens captures a lot of some of the concerns that folks in the civil rights and racial justice community have when we think about algorithmic decision-making, and particularly the notions that trade secrets protections will prevent you from being able to examine how these decisions are being made. So just to kind of go very quickly through kind of some of the principles I think are related to what we might think of as solutions to some of these problems. Critical race theory is very much concerned with narrative, the story that's being told. Yes, data and numbers are very important, but the story that's being told is also important too. And the reason why the story being told is important is because there's a focus on the individual who's being harmed by these systems of oppression. I think when we lose sight of the individual who's being targeted by these systems, we lose something in the sauce that we're trying to make. If we look at the world through that perspective, through that standpoint, one that's often not represented in the rooms that are designing these tools, the rooms that are implementing these tools, the rooms that are kind of providing oversight of these tools, we'll come up with a different set of answers, a different set of questions that we really should be asking all the time. To the extent that we're thinking about secrecy and trade secrets, I think it's really important when we think about from the perspective of the person being targeted, what we're doing is choosing the interests of a corporation or a developer over the interest of the person who's being targeted. And if you're in a position of being judged by a machine or by a tool, that's not going to feel very good, to put it bluntly and put it very mildly. I think the other piece of this, from the standpoint from the standpoint of critical theory, is, one of the things that Derek Bell was very well known for, saying often over time and time again, was his concern that racism, the condition that all these tools, at least in the criminal justice space, when we're thinking about trying to reduce biased decision making, is a permanent feature of American life. It's not going away. To put it in kind of terms that folks in the computer world might understand, it's a feature, not a bug of the system. It's the way things operate. And so when we're building technology and we're thinking about how these things should work, the goal is not to kind of solve racism. The same way that you build a bridge, not because you're trying to defy gravity, but you're trying to get from one point to another. You see a river or some other obstacle in the way, you're trying to build a bridge around that obstacle. So I think when we think about building technology and designing technology, part of the task is to realize that the thing we're trying to fix, the thing we're trying to resolve, is unresolvable. It hasn't been resolved in my lifetime. And I used to have to point to kind of slavery and all these other things. You could open up the paper or turn on the TV and see a caravan of people of color coming from countries that have been, through American policy and through other policies, ravaged, essentially, brown people, and the people in this country's government sending military force down there to stop women and children. That is rooted in race. Okay, and that's part and parcel of kind of the world that we live in, and something we have to really grapple with deeply. And so when we're thinking about kind of designing technology, that's part of the problem that we have to confront, and part of the thing we have to keep in mind. Another piece about critical theory is this notion that the law often is designed to perpetuate power and perpetuate itself. And what I see when I think about trade secrets, and I'm not a trade secrecy lawyer, I don't know that much about copyright or patent or any of these things. I'm a criminal defense attorney, a civil rights attorney. But what I see is that essentially trade secrecy is used to control access to information. And reality is that information is power. To the extent that we're willing to cede ground to trade secrecy, what I think we're doing is essentially playing into the same critique of the law that we already have in place, which is that it's perpetuating a system that we already disagree with or have a problem with, because we're just ceding power to a whole a cast of folks who might not have the interest of the people being targeted by these systems in mind when they're designing it and thinking about kind of throwing this trade secrecy concern up in the air. I think the last thing that I'll say, and it's not necessarily related to critical race theory, but I think it is something that's worth keeping in mind, is that while transparency is phenomenal and incredibly important, particularly in the criminal justice space, where you want to know how and why decisions are being made about an individual, the reality is that transparency is simply not enough. What's required is some measure of accountability, and that accountability coming from people being harmed by these systems. A really, really relevant, I think, clear example of how transparency is not enough is we had a system in this country that was incredibly transparent. Everyone knew exactly how it operated. It was widely understood that if you were black and lived in the United States from the 1600s to the late 1960s, you were living under an apartheid regime. Everybody understood that system. Very transparent, very clear, but without any lever of accountability, nothing would have changed. And so I think it's important when we think about trade secrecy, think about the notion that getting over the trade secrecy hump is fantastic, but it might not be enough to kind of win the day and actually advance justice in the way we want to see it happen. So That's my, I hope I'm out of time, because that's all I have to say.
Perfectly timed. Thank you very much. So we're going to take questions, and we're going to do it from the back corner this time, because there's been a left side bias. I am just going to ask a quick question to you all, and how I'm going to frame it is through two hypotheticals, and I'm putting you in teams. So the first hypothetical, which I'm going to ask to Andrew, Colleen, and Vincent, is we've heard, we've had this case study like throughout the last 2 days. The figure of Mark Perlin has loomed large, and concerning trade secrecy in the criminal justice context. And I just want to imagine a case being fought a decade from now in which each of your individual solutions have had their decade. So we have an algorithmic regulator, Andrew, and it's been very productive and generative. Colleen, there's been all this research on, led by technologists working with like-minded lawyers, and Vincent, critical race theory has finally been, absorbed and considered by many more people than
This really
it
is a
should
fantasy.
be. It is fantasy. So fantasy land.
It's really hypothetical. Okay.
So how do these cases play out? We've got a trade secrecy, trade secrecy claim coming through, and we've got a criminal defendant who wants to get access. What are the implications of running through absorbing your solution?
As a lawyer, you're never supposed to say, like, that's a terrific question, but actually that is really a terrific question. I think it really makes this concrete. So thank you. So somebody, if you had a trade secrecy claim in a proceeding like that, under my vision of how the regime would work, the trade secrecy claim would win. The maker of the sort of software system would have made whatever limited disclosures were necessary to the regulator to show that the algorithm was safe and effective for its intended use. And whatever the acceptable latitude of error and bias that was in the algorithm has been sort of assessed and judged in sort of according to agency documents or whatever that hopefully I think the public would be able to assess. And so in the specific use case, you ultimately would not be able to bring a claim to get at the source code or the training data.
Yeah, terrific question. I think it could look a couple different ways. One would be, the public defender also has access to data science evaluators who can interrogate and go inside the black box and make discovery that's relevant to the case. That's the adversarial, I think, current system. I also see a system that looks more like our sort of expert witness system, and in particular, I want to weigh on a intervention that I'm advancing in the patent space, which is the use of neutral experts. But again, where we might have a space where independent neutrals, either from the community or from trusted groups or others, are able to take a look and represent the interests of the community in seeing how the algorithm works. Another iteration of this could look like a test set. So I'm going to refer to this as a little bit something I didn't talk about too much, but if you have seen sort of the trajectory of how data science has developed in certain realms, you have what's called a training set that's put out by, whether it be, a challenge around car or autonomous vehicle performance, or the most famous one is ImageNet that was put together by Fei-Fei Li of Stanford, now of Google. And so she developed an independent way to evaluate algorithms where you didn't have to show every detail about the algorithm, but you showed how it performed against this benchmark. And so having that there, where there may be independent benchmarks where we can evaluate things, will eviscerate the need for, I would say, the adversarial process, so the attritional alternative.
Thanks.
Okay, so I guess I have three answers. One, so we're looking at 10 years from now, if you accept my kind of theory and framework, the criminal legal system is done. So there's no system that we have to fight this out in, because the reality is that I think these tools, what we're doing is really kind of tinkering around the edges of a system that needs wholesale change. And as I think Dana said before, just burn the whole thing down. So that's like my first answer. To the extent that hasn't happened, I think the second piece of this is within that kind of context, the trade secrecy claim would be irrelevant because you wouldn't be using risk assessments. Essentially my view is that what we're doing by using these tools is profiling populations and forecasting, using those profiles using those forecasts to profile, using those profiles to forecast what people might do in particular situations. So you wouldn't be using risk assessments anyways, because I think profiling is fundamentally antithetical to a criminal justice system that's supposed to provide individualized justice. But if those two things don't happen, the final thing I'd say is that the trade secrecy claim would lose, because fundamentally I think that sunlight is the best disinfectant, and the reality is that I can't trust all these other systems to operate in a way that's going to be beneficial to people who have been charged with crimes, because the system has never been beneficial to people who have been charged with crimes. And so I think at bottom, there would be no trade secrecy claim, because the kind of designer or builder of whatever tool it is would be forced at the outset to provide all the information that they had about what went into the kind of secret sauce, so to speak. So in my world, the person who's charged with a crime down the road would be a much better place.
Great. Okay, this one's quick. They were great answers. So now, Natalie, Sonia, Andrew, here in New York City, we had a little brief mention of it yesterday around this algorithmic task force. There was originally a proposal for source code disclosure. It got kicked into the long grass, and now they have a task force, which hopefully is going to be very generative. But one of the things I found in talking to people from the city is that they essentially conflated trade secrecy and commercial secrecy, and they were really worried about missing out on the edge of innovation, which is, for New York City, quite extraordinary. So taking your different perspectives, Natalie, your ideas about innovation policy, these wonderful 6 personas, Sonia and Andrew, your examination of power through the prism of Scott, you're advising New York City. You want to either get them to push back on this trade secrecy, give them some confidence in negotiation, or push them into new policy areas. What's your one big takeaway that if you can get them to do what you want to do in advising the city here?
So I would advise them that they've got lots of options, and most of them don't require non-disclosure. And so I think one thing that the city could do is to set up a kind of a grant funding process, both for the development of algorithms specific and validated for the city, and also provide grants for outside groups that could then do outside validation,
yeah.
right? So I think grants are important on both the funding of the development side and also on the testing side by outsiders. And in addition to grants, all these other things, regulatory exclusivities and the like, that can be substitutes for secrecy.
Great. Just while we're going, can someone come grab the mic so that you guys... Oh, you've got one. Perfect. All right, Andrew.
Yeah, so, well, Scott's sort of this power analysis kind of theory. I don't know that I would directly use it. I mean, I'd probably tell them implement algorithmic impact assessments, which, if you think about Natalie's proposals as the carrot, is the actual stick that says, you just have to do things in a transparent way, but talk about your process of development, but not in a way that necessarily discloses trade secrets. You could talk about how you tested your system, how you, what things you chose and what you did, where you got your data, those kinds of questions, and just in a public way that can be challenged. If I was talking to them too long and I had a couple of drinks, I might have said, stop thinking about innovation at all. These rich companies are only getting richer, and why do you care? So, yeah. But that's only after a couple drinks. So sure.
Okay, so me sober, I probably would. I actually think that I might actually just require the government to go open source and just make everything as transparent as possible. I know that it doesn't solve all of the problems, but I think that to the extent that you can ensure more transparency, I think it's better. And then I think to the extent if we can't do that, then I would definitely provide for systems that really allow for a very thorough and fair investigation for consumer advocates in automated decision-making.
Terrific.
So I wanted to thread or propose to thread something that Colleen said with Andrew and the sort of power analysis, and then this idea of why the power is not in the person who's impacted by the tool as much as it's in the government. So Colleen during the presentation said that communities should be involved in deciding what risk should be assessed in the first place, which would sort of change what data is collected and would change the different types of questions that the entire algorithm system in the first place is oriented around. And if I was, and in some conversations with grassroots groups who are talking about what these algorithmic systems are looking like in the pretrial context, for example, they are saying, I don't want to know the risk of a person's future behavior. I want to know the ways that these instruments are actually predictive of what that judge is going to do. So how can we use these same assessments and these same research methods to determine how much risk I'm facing by going in front of that judge, for example, and turning the assessment away from the person who has been accused of a crime and turning it back on the system and saying, how can this tool and this research method be really used to articulate with specificity what we know is true, which is that the system treats people of color differently and treats poor people differently and treats people with different residential statuses differently. And so why that doesn't happen, of course, is because the consumer power of the person who is accused of crime is so little. So how can that idea of involving people in defining what risk should be evaluated in the first place, but changing the power dynamic so that they have more purchase in getting to decide what companies are investing data collection and their mathy brains around? How can we create that assessment of the system? And is the work already done and all we need to do is sort of add the data point of who the judge is to be able to turn it around? Is it that simple, or do we need to really scrap everything and start over, as Vincent and Dana said, and I concur with?
Well, I would just answer in a very prosaic way, which is to say, like, I think that you just need to get more data scientists to understand that is an interesting thing to do and that they should do it, and you can get people involved in it. One problem with doing this is you would need to code a lot of court-level data, which right now is in really poor form. I've been working with it, in different jurisdictions. It's very county level. Depends on which state you're in. There's not necessarily a common criminal identifier across different databases. So you have one person, one county, and some person another. You don't know about them, and you don't know what the judges, what they do. You need to look at their outcomes. Looking at the court data. So the data right now is like in a lot of different places. It's not clean. But if we had it, we could do that. And I know this because I advise companies, one of them is called Lex Machina, that do this work in other spheres. So in the patent world, for example, we have what's called patent moneyball. Once you get your judge, you know very well like how hard they are. You do this for examiners as well. You kind of know what their risk is, what their rate of allowance is for a patent. You know like what kinds of things they like to argue. You do have this scrutiny on the evaluator, and that company, which was a Mark Lemley from Stanford, he started it, but I've been involved with them since the beginning in terms of like how they get that data, and it's it's a big pipeline, a lot of work that goes into coding it all, and then being able to do that. But then what happens is you'll get your information about which judge you're assigned to or the examiner, and you'll make a decision based on that. You'll rationally say, oh, I'm going to just give this case up because this guy has a 2% allowance. Has it actually created more consistency in the patent office? No, I don't think that's happened, but there is at least decision-making that's informed by that. So it's totally possible, but it takes will, and again, the data sets here are very dirty, so there will be some data collection that have to happen, but data science are I would say very amazing. They can find data, they can clean it, they can do it, but we need to get them excited about it.
So I'll just say really quickly, I think, it's a incredibly great question, and I think it's one of the things that I always kind of call for is using these tools and pointing them back at the actors in the system, particularly if you think about police officers, what officers are, if I have an interaction with an officer, am I more likely to end up dead or hurt because of that officer's kind of past or their prior behavior? I think one of the things that is important is I think not only having like data scientists kind of interested in this, but also one of the other things that I think Professor Bell talked about with this notion of interest convergence. And, you know, what that kind of theoretical framework says is essentially that disfavored group will never kind of advance in any way unless it's in the interest of the group that's already in power. And so once it becomes in the interest of a judge or a police officer or a prosecutor to have like their behavior evaluated in some way, that's when you'll see these types of tools be developed. But until it's kind of within their interest, or in the interest of some powerful entity, or some powerful, so I can imagine if the folks who don't typically go to criminal court are caught up in the criminal justice system, and they have a problem with the way in which it's operating, and they're a member of a powerful kind of group or a dominant group, that's when you see, I think, the motivation to kind of create those types of tools. But until then, I think what history has, I think, demonstrated is that until those kind of interests align, essentially there isn't kind of the motivation to do that type of work. And the reality is, part of it is because nobody likes to be judged by what other people have done before. Cops don't like to be judged by that. Judges certainly don't like to be judged by that. And so it's kind of like this goose gander thing, where the people who are targeted by these tools, is like their feelings don't necessarily matter. Like it's fine to judge them by them. So it's like a whole other rant. But that's kind of like my personal view about it.
Gabriel. Thank you guys so much for offering so many incredibly interesting ideas. Over the course of the last 2 days, it seems like we've been talking about two different types of algorithms, but we haven't been really drawing a clean distinction between them. So on the one hand, you've got algorithms like TrueAllele and StarMix and potentially also PredPol that are really supposed to be used as you get an output and you follow the output. So TrueAllele, StarMix, it's a probability, but like it's telling you that this person's DNA is the DNA. Whereas in sort of the second bucket, you've got an algorithm that's supposed to work not just by spitting out an answer, but by giving you sort of a taxonomy of information that then you're supposed to use. So in the risk assessment tools, whether they're pre or post adjudication, you get a risk assessment, but then the judge is supposed to use that data to make an individualized decision, which strikes me as a very different thing than just, did this person's DNA go into this mixture? And obviously, in both of those situations, trade secrecy and secrecy in general can be problematic because we don't know whether the first sort of situation, we don't know whether that TrueAllele system actually works. And we may not know the quality of the data that we're getting in the sort of suggestive mode in the risk assessment tool. But I was wondering, to what extent should we be thinking about tailoring our solutions? Like an FDA for algorithms works really well if all we care about is getting the right answer and there is an objectively right answer. It strikes me that that would be much less useful for a situation where, like, a judge is supposed to take into account a risk assessment, but is also supposed to be making an independent decision. In that situation, you would want to be able to argue the individual in the narrative. So it seems like there's more of an interest in disclosure in the second one, but I might be wrong. And I'm wondering to what extent creating that taxonomy might change the way we think about one solution as opposed to another, and what context they'd be appropriate in.
Thank you. I really appreciate the focus on the complexities here, because actually that's sort of always been the reason that I sort of am in the FDA for Algorithms camp. When I hear solutions at conferences like this one, I often find them to be reductive in a way that is actually almost impossible from a regulatory standpoint to grapple with the complexity of the issues involved. So a good example is source code disclosure. It's a popular thing to throw around. But the source code disclosure on a machine learning algorithm is going to tell you almost nothing about the algorithm, right? And so, like, we have all these like proposals for transparency that are often thrown around, and the transparency is not actually going to be productive for the ends that we seek to achieve, because we don't have an appreciation of the technological sophistication of what we're actually dealing with. Whereas my proposal for a regulator is actually about having a group of people who are actually people who understand this technology at a deep granular level, working with policymakers to produce sort of tailored solutions. So when you, what you're talking about really is about sort of human-machine interface sort of algorithms where there is a partial machine solution, partial human actor solution, and it raises incredible difficulties about liability, about responsibility, about causation. Those sorts of things require tailored solutions that really reveal the difficulty of the regulatory challenge that algorithms pose right now and will pose in the future. And so that's why I actually sort of stand by my sort of sloganeering FDA for algorithms kind of approach, because it actually, inside that phrase, is a lot of sophistication.
So I just actually wanted to push back a little bit on the premise of the question. I think there are a lot of different kinds of algorithms out there, but you might think there's a difference between something like probabilistic genotyping, where you're getting an answer and you know there's a right answer, and something like, actually where I put predictive policing in the other camp, where you're trying to predict something ahead of time. But the fact is, if an answer might metaphysically exist in some sense, but it's unknown and unknowable, then is there any way in which there is an answer in the sense of wanting the software, right? If the answer were knowable, we wouldn't need the software. And so I don't know that there's just like such a clear distinction between the types, like predicting something that is unknown but happened versus something that's coming in the future. They're both predicting things that are unknowable. And so, I mean, sure, there are, in every area, there are reasons to appreciate the complexities of different kinds of algorithms, and it might be worth having different approaches. But I'm not sure that distinction is one I would completely buy.
Lala.
Yeah, so thanks, guys. I also have really enjoyed the whole conference and the panel in particular. Sonia, so I really appreciated you sort of bringing back to like this important distinction between understanding the secret as trade secret law as being about misappropriation rather than disclosure. So there are two ways in which you could understand a right to your secret. It's a right against being betrayed versus a right of control. And so it kind of maps onto, like, as people have mentioned, a more tort versus property conception of trade secrets. And so I'm a philosopher, so I was thinking about this philosophically, and just even on a property picture of what the thing is that a person who has a trade secret has a right to. You have a right to control your property, but that's also limited. Like, you can't do just anything with your property. There are limits to your right to control, and in particular, you can't use your property to violate people's rights. So it seems like there's a really important difference, even within the property picture, between like owning a trade secret and selling like special sauce, or an algorithm that like makes like really great playlists and things that are just producing like enjoyment for people, versus one that's like causing harm to people, and harm that could at least possibly be a violation of people's rights. And so just thinking about this, it seems really absurd that when someone's using their property to harm someone else in a way that is potentially a rights violation, that this person wouldn't even have access to the information necessary in order to determine whether a rights violation is in fact occurring, or whether the thing that's happening is actually, totally morally fine. So I was just wondering if you have any thoughts on that analysis. That's
a really nice set of thoughts about sort of the uses and disuses of property. But yeah, I mean, I think that you're entirely right. I guess one thing that I often think about, just because I come at this as an IP person, is in terms of the way in which source code is dealt with, at least in the infringement context, there is a fairly sophisticated system that courts have been drawing on for years that allow for investigation of source code and related aspects to check against infringement. So I actually find it somewhat fascinating that this seems to be just such a huge obstacle in the criminal justice context. And So I have a paper that's coming out in the Cornell Law Review that talks a little bit about this. And one of the things that we do is we, look at a bunch of these cases and we say, like this is totally, common in patent infringement and copyright cases that deal with source code. So it's just fascinating to me that here, where you have even more of a need, particularly a Sixth Amendment concerns. It's amazing to me that there does seem to be these obstacles, and also that courts are happy to embrace them. I think the wrinkle that I would add on to what you're saying that I think makes all of this even more complicated is the increasing kind of privatization of public functions, because that to me is the thing that is the big elephant in the room here that we haven't really talked about so much. But the way in which public entities are able to kind of delegate these governance functions to private entities and therefore immunize themselves from the responsibilities of transparency and accountability, I just think that to me is I've been thinking a lot about wanting to do more documentation around that, because I think that's kind of the issue that I think is the most critical one that we really need to be thinking about. But the property issues, I think, play into this perfectly, right? So you can do things with your property in the private context that you just can't do if you're in the public one.
Great. Gina?
So there's so much here that I have really appreciated the conversation. The privatization of pieces immunizing public functions, I think, is a huge one. I think about the phrase "big brothers, little helpers," and what is the relationship between companies and the government. Interestingly, the interests of companies and governments to surveil individuals. Surveillance helps you sell things. Surveillance helps you control people. To me, I think. And also the focus on it being an issue of power. So I think power corrupts, and the more power you center in one place, the more corruption you get. So healthy societies, healthy systems of government spread power around. Watchdogs, many eyes. And so in some sense, digital technologies are a powerful thing. They can be good they can be powerful for good or for evil. And in the one lever we get, though, is the idea that it had to be specified. In contrast to black box human decision making, there is a specification that exists and that can be understood. So it's not surprising in this balance of power world that we're getting the desire to use these powerful tools without the specification or the balance of power. So I'd like to think about this from the perspective of what can we do to change this balance of power over these tools? How can we get more accountability? In this sense, I've been thinking a lot about the role, the intermix of human decision-making and machine decision-making. What are machines good at? What are humans good at? Is there a way we can influence the system to get the best of each rather than the worst of each? And I think one of the ways in which we're starting to get the worst is the shifting of the karmic cost of hard decisions into black boxes that allow people to say, I didn't do it, the computer did it, I'm sure it had a good reason. And I was especially struck by the comment about that when you do look at the specifications, what you see is this double-edged mitigating factors or aggravating factors. Of course. When you look at why you might want to punish someone, what you mostly learn is that it's because they didn't get the help they needed. They were too young. They were too in a deprived environment. They were mentally incapacitated. So the same things that we want to punish people for are the things that, when we really look at the reasons, we might want to help people. So with human decision makers, at least you get a call to the empathy of that person, that these people need help. And in machines, you get the ability to push the karmic costs of those hard decisions away. Basically, my question is, what can we do to have humans and machine decision-making work together and to influence the balance of power, of checks and balances in a system to push it more in the direction we want to go and less in the direction it's currently going.
Natalie and Andrew, I don't know if you want to think about an answer to that. We'll just take Seb's, if we can keep it quick, just because we're right up to the line here.
Yeah, sure. I feel like so many of the things like walked up to say have just been said, but I guess my sense is that the IP discussion here winds up politically boiling into something about privatization of public functions. I guess and then the other sort of dimension of it that's come up is like prosecutors being overpowered relative to defendants. And I guess I'm curious about how much of it is a matter of ideology versus a matter of fact, that the privatizing powers and the prosecutors are both, to some extent aligned on the use of the private technology. And is that what this is really all about, as opposed to the nuances of IP and competition law, or is there actually something going on in the kind of technocratic discussion of IP law and competition and this and that that's actually like substantive for the question of justice in this case?
Okay, so the question about how do we get a better balance between people and machines is an excellent one, and a really, really hard one. So, I mean, in my article, I suggest that as much as courts seem not to care about getting the science right, we probably actually have to depend on courts to be the first mover here, because they're not going to move until legislatures do. That's what we saw in New York, right? The court demanded disclosure of the FST, then allowed the FST to be publicly disclosed, then the Office of the Medical Examiner abandoned the FST, and then we get this kind of legislative proposal that resulted in the task force, right? So I don't think, I'm a little depressed about the possibility of legislatures leading the way. I think courts in individual cases are going to have to lead the way, at least when we're talking about evidence produced by algorithms that's actually introduced at trial. And that if courts start demanding disclosure, right, then legislatures will be in a position of saying, oh no, if we don't provide these other incentives for innovation, we're not going to get enough innovation, right? In which case they can step in and add all these other alternative innovation levers, or they'll discover that in fact we don't actually need trade secrecy, that it was just a kind of icing on the cake of economic benefit for the algorithmic developers. And so, as maybe a long shot as it seems, I still think courts are probably our first, last best hope, maybe.
Andrew.
So, I don't know about how we get there, so I'm going to actually talk to Seb's question more. But like, is that what it's all about? Is it all about this power thing? And part of me, I mean, sitting through this conference, I'm not an IP guy, but it seems more and more, and I sort of thought this for a while, that the trade secret claim really is just a naked exercise of power. It has very little to do with IP in my mind. It's using whatever lever we have to assert corporate power over government functions or just to make more profit. And when you have prosecutors asserting trade secret claims on behalf of absent companies, like what else is that? That's not law, right? It's convenient for us because we don't have to be accountable anymore. I don't see how else to think of it other than a somewhat lawless, though actually apparently ratified, naked assertion of power. And I mean, part of it, I should say my priors here, I have very little sympathy for innovation arguments in general. And a lot of the reason is, to me, it seems like I don't know what a society with not enough innovation incentive looks like, because we've never had one in my lifetime. And there's no end to the argument There's no end to the argument that we need more innovation incentives. We could think about theoretically, oh, hey, maybe we're over-incentivizing this person, and so these other people are not having the incentive, but it's a one-way ratchet. And so to say that we need trade secrets for incentives, I mean, maybe, but it seems like also maybe not, and there's just no value to the argument in any sense. Like, I bet we're better off if we just abolish trade secrets entirely, or at least in software. But, you know, I'm not going to say that as a proposal, because I'm not an IP guy. But this is what it seems to me. It seems just like just raw exercise of power because that's what we give them, and that we allow this, and it's unconscionable.
I definitely agree with that in terms of raw exercise of power. In terms of how we get there, I mean, I think there are, in some ways, tools in the toolbox. The problem is that we just don't take those tools very seriously. And so you think about like concepts like due process, procedural due process, substantive due process, like these are constitutional rights that if we, I think as a society took them more seriously, it's supposed to shift the balance. I mean, it's supposed to, like those kind of provisions of the Bill of Rights are supposed to serve as the kind of checks on those raw exercises of power. And I think, you know, part of it is like the interests, like whose interests are being served, and who are the kind of decision makers who are able to kind of decide whether or not we're going to take those concepts seriously. People kind of talk about how risk assessment has really revolutionized things in places like New Jersey, in some kind of far off counties in Ohio and other places. But the reality is, in each one of those places, those systems have kind of, completely overhauled their pretrial justice system, including providing much more robust forms of due process protections to people who are being accused of crimes. So, in terms of getting people to work together, machines and technology and people, part of the issue is really making it very, very difficult to put people in prison or put people in jail. So you provide them with hearings, you provide them with lawyers, you provide them with resources, you provide them with all the things that will force issues that the machines are not, or the tools are not picking up in front of the judge or in front of the decision maker. So that's kind of in the picture. So I think that's kind of maybe one answer, but I'm sure there are a lot more that I haven't given any thought to.
Look, this is a great panel. I'm sure we could all continue to discuss, but we're going to have to bring it to a close. I wanted to just say it's been so terrific over the last 2 days to have so many people whose work we admire and respect come out to spend this time with us. Also, the whole audience has been invited, and we really appreciate everybody who's been here. I think having Cynthia, Celine, who's been here the whole time, Amadeus, we had Chris, my colleagues from Cornell Tech, really terrific group of people, and all of our fabulous speakers. I'm going to call on one last audience participation thing. This will be off camera. When I do stuff with students and school kids, I like to end with something that you've liked and something that or something that you'd hope for. And I'm going to give the final word to Rochelle and Kathy as co-conveners, but people think of something that you liked and that you would hope for. I'm going to give an example. Something I really liked was how people adapted yesterday to the theatrics of the slideshow and kept us in the game. Something I'd hope for, I think it'd be nice to see more US conferences where we bring people from other countries. Often that means they're in different traditions, different styles, but I think it's really important. And I just wanted to say what an absolute pleasure it's been to co-organise this with Rochelle and Kathy and with Nicole. All three of them are just an absolute masterclass in attention to the detail of both the substance and the whole practicalities, presentation. I think we really paid attention to who we had and to getting a diversity of experiences together. I think the food was excellent, venue, everything worked seamlessly. So just a huge round of applause for Rochelle, Kathy,